The Ministry of Finance and the Public Service presents Let's Talk Finance, a feature exploring the various elements of the economic program.
Welcome again to Let's Talk Finance here on Nationwide 90 FM. My name is George Davis. This is the spot where we talk about matters pertaining to the financial activities of the country. My guest this morning is Senior Director of Legal Affairs at the Jamaica Customs Agency, JCA. Her name, Hazel Edwards. Hazel, good morning. Welcome.
Good morning, George. Thank you for having me.
Good. Let's talk about the JCA and amendments to the Customs Act. I remember in 2015, there was an announcement by the then Minister with Responsibility for Information, Senator Sandra Faulkner, about amendments to the Customs Act. She said words to the effect that the amendments then were to make the Customs Act wieldy and reflective of modern considerations, modern demands on the customs agency, and of course to allow the new legislation to usher customs towards a direction where it could marry with the whole move towards a logistics hub. For this round of amendments, what is the difference between what you're intending to do now as opposed to what was done previously to amend the legislation?
Well, George, the objective remains the same, to ensure that we capitalize on the move towards a logistics-centered economy and ensuring that the legislation is fairly easy to use and to be understood by all our stakeholders. But now we're not focused on amendments. We're actually moving towards a repeal and a replacement of the Customs Act. So we have legislation that dates from 1941, and we're looking really to set that aside and put in place a brand new piece of legislation. So whereas in 2015 we were amending, and in 2014 we also amended, so we took bits and pieces and changed it.
Yes.
Now we're looking at a wholesale overhaul of the legislation.
Fine. So the natural question that arises, a wholesale repeal and replacement versus amendments where, of course, you repeal certain sections, you strike them out, you add new things. What was the thinking behind that? Was it that the amount of work that was necessary was of such a large scale that it was better to just draft something anew and implement it?
Well, the focus was not so much on the work. Doing a repeal and replacement is a significant amount of work. But the driver really is to ensure that we have legislation that really has really is motivated by the principles that we want the legislation to be motivated by. Now, it doesn't mean that there are not a lot of good things in the current Customs Act. And what works, we intend to keep.
Yes.
But there are some core principles that are characteristic of modern customs practices, and we want to ensure that we have those. For example,
Yes.
the idea that customs should be motivated by risk. That's a key principle that was not a part of the legislation in 1941.
Yes.
But today, customs wants to be more targeted. We want to use risk management to decide who we examine, what shipments we look at, where we focus our resources. And so we want legislation that has that at the very heart of it.
Mm-hmm. In terms of your stakeholders, though, the people, well, let's call them your various publics that customs interfaces with, what have they contributed to this repeal and renewal process? Let me call it that. In terms of what have they said about how the legislation is, perhaps the wording, if it was from 1941, I'm imagining that the language is outdated. Yeah. What have they contributed to the process that will now be implemented to repeal and replace?
Well, our stakeholders have been a very key part of the process. They have been very vocal. And sometimes the conversations have been very robust and interesting, but that is the kind of conversation that we want to have. Our stakeholders have said to us, listen, this legislation is cumbersome. The language is outdated. You have an entire section that has 10, 20 lines with very little punctuation in it.
Yes.
It keeps lawyers employed, and that's a good thing as counsel myself.
Yes.
But it is perhaps not consistent with modern practices. You want to ensure that stakeholders are able to use the legislation in a reasonable manner. And importantly, that they have a very clear understanding as to what their obligations are. So the law should allow for that. So they've said to us, we want language that is modern, that is fairly easy to understand. And that is something that we have taken forward in the process, and we're looking to ensure that the legislation does in fact achieve that. Our stakeholders have also said to us, for example, that Customs takes decisions on a daily basis that impacts their livelihood, impacts their businesses. And they want to be able to have a clear administrative process by which they can appeal decisions made by Customs. Now, in the current legislation, appeals can be made in respect of decisions of the Commissioner in respect of assessment.
Yes.
There's an administrative appeal process. So if the Commissioner says you are to pay duties or how much duties you are to pay, then there's an administrative appeal process for that. But there are many other decisions that are taken by Customs that do impact persons. And they should have an opportunity to also appeal those decisions without necessarily resorting to the core processes, which sometimes can be time-consuming as well as expensive.
Yes.
So that is one of the key principles that we want to ensure. We're looking to put in the legislation administrative appeal processes for all the decisions that are taken by the Commissioner of Customs, because we recognize that there are times when we disagree, and persons should have an opportunity. It is fundamental to fairness that they have an opportunity and a clear process by which they can challenge the decisions of Customs, and even to have that administrative appeal being heard by a body external to Customs. That is not the courts.
Yes. I would assume that the admission by the powers that be at the JCA that there's need for repeal and replacement of the legislation is motivated largely by the fact that there's a misalignment, or there was a misalignment between the existing legislation and the business of Customs. You've cited several examples, but the two main areas that you will eliminate in terms of inefficiencies under the old legislation, when you put the old legislation against the business of Customs, what will this new legislation now bring forward and eliminate in terms of the things that used to affect the smooth flow of the process between customer and Customs?
Well, I spoke before about risk management. That's an important factor, right? We don't want to have a customs administration that is dependent on physical inspections, that is dependent on sort of guessing and spelling, right? That's not beneficial for Jamaica.
Which is what exists now.
Right. Customs has a role for border protection.
Yes.
Now, let me say not what exists now, because Customs has been using risk management for some years now. What we want to ensure is that there's a legislative foundation for us to continue to do what we've been doing and to go even further, right? Because if you think about it, if a person has a record of compliance with customs laws, should they be treated in the same way as someone else who's not complying? That should not be so.
Yes.
A person who is complying should benefit from facilitations from Customs. You should have expedited clearance and release. Customs should recognize you, if necessary, granting you a particular certified status or so, which allows your goods to move very quickly.
Preferred compliance status.
Exactly, because we know you are complying.
Yes.
And then we can focus our time and our energies on those persons who may not be complying and see what it is that we need to do to get them to also be compliant. And for the most part, the majority of business persons, they want to comply with customs laws. They're about business.
Yes.
And so the Jamaica Customs Agency we recognize that, and we want to recognize that they are partners in the process with us.
Everywhere you have doubting Thomases and doubting other surnames. So here's what people will probably say now, Hazel. This is a move designed to increase exponentially the fines under the Customs Act. And it is a better sell for the agency. They say, well, it's a function of having repealed the old legislation and putting in new legislation rather than putting in amendments to the existing law. And it's a cover for that. It's a charade. I can hear business people saying that. Your response?
Not at all. Not at all. In fact, the focus of this repeal and replacement process is not about fines. Yes, you must have effective deterrent measures in any legislation, because there are always going to be those persons who are determined not to comply. But that is not the focus. In fact, so much have we shifted away from that, any sort of thinking about that. one of the things that we're introducing in the legislation is this idea of voluntary compliance. And the idea behind that very simply is this. In the event that a person gave incorrect information to customs that resulted in them not paying the duties and taxes that they're liable to pay, there is the opportunity, we're putting forward, the opportunity for persons to come to customs and to say, here it is that I made this error. I am going to now pay all the duties and taxes that are due. And in exchange for that commitment, the Commission of Customs will not commence proceedings in a court of law in relation to that person or not impose any penalties against that person. But what that is really saying is that we're shifting, we're focusing more on compliance.
Yes.
And that has really been the move for several years now. That is the thrust of the Commissioner, that's the thrust of the Ministry of Finance.
Yes.
And that is really where we're focused, not on punishing persons, but on recognizing that, listen, it's life.
Yes.
Sometimes things go wrong, things happen. Let us settle the duties and taxes that are due, ensure that the revenue gets what is due to the revenue, and then let us get on with the business of doing business.
Yes. On the point of the preferred, my phrasing, the preferred compliance status that entities and persons can have if they maintain a spotless record in dealing with the customs agency, will there be built into the legislation the requisite safeguard so that someone can credibly say, look, my record on paper is not spotless, not because of anything I've done, but because of an issue in dealing with the customs agency and the inefficiencies on the side of customs that have caused my record to be spotless. And really, in real terms, I should benefit from preferred compliance status like John Brown or John Tom or whichever businessman. Will those safeguards be there and the dispute resolution mechanisms clear so that persons can really believe that there is credibility in the interactions between themselves and the agency?
Indeed, George. And that's how we go back to the first things that we started talking about. The idea that the law must be clear and simple. When the rules are very clear, everybody understands, and what we're playing with, customs will know what our obligations are, and the stakeholder will know what their obligations will be. And then we get to the dispute resolution mechanisms. Persons must be able, if customs says, listen, you had a certified status, you had a preferred status, now we're taking it away because of these reasons, you must have an opportunity to challenge that decision, and to challenge that decision very quickly, because we recognize that when it comes down to business people, they don't want to be spending 6 months, a year or so going through a court process.
Yes.
So the dispute resolution mechanism must be simple, it must be cost effective, and it must be fair. And persons must be satisfied that they will be able to get a decision from an impartial tribunal. While at the same time, mind you, we're not closing all the avenue for persons to go to court. They will continue to have that option if they wish, but we wish to give them alternatives so that all parties, we know the rules, and when we disagree, there's a very fair and quick way for us to resolve those differences.
So if I may sum up what you're saying, Hazel, the legislation is not to punish or to impose punitive measures on the people you do business with. It's to make doing business better for all parties concerned.
Indeed, it's about transparency, it's about fairness, it's about putting compliance at the forefront. It's about using risk management to decide how we go forward and partnering with our stakeholders, listening to them, getting their suggestions on board. And in fact, throughout this process, we've been talking with our stakeholders. In the next couple of weeks and months, we're going to be engaging our stakeholders very, very actively. We want to get their input. We want them to tell us, Customs, this is what you've been doing well, or Customs, this is what you have not been doing so well. And here are our ideas. We're open, we're ready to listen. We view our stakeholders as partners in this very important process.
Senior Director, Legal Affairs, Jamaica Customs Agency, Hazel Edwards. Thank you for your time this morning.
Thank you for having me.
That's it for Let's Talk Finance.
That was Let's Talk Finance, brought to you by the Ministry of Finance and the Public Service.